Yeah.
Good morning, everyone. Welcome to the weekly Saturday knowledge sharing webinar organized by Mehta and Mehta. Thanks a lot. Today, our topic is webinar on Masterclass on Companies Act 2013. Our series is there. And today's topic is an insight into the provisions relating to inspection, inquiry, and investigation. It's a very unique topic. Very few webinars get or seminars get conducted on this topic, though it is a very crucial. And when it comes to any company, it's bring BP to every professionals, promoters, directors, and everyone is on the toes. So it is very much necessary we should discuss this in a depth. Everyone wants to go away, run away from this topic, but the thing is that we have to face this. These are facts of the life. We have to also face this situation and not to worry, get feared, but to have a more knowledge and how we can attend that, and so that it can be attended properly as a professional. And as a professional, you can help your client or your company where you are employee. And so this topic we have going to discuss in depth. Our partner, Namrata, associate partner Namrata, is going to present the presentation. Thanks, Namrata. And Namrata Tatia is a fellow member of ICSI with 8 years experience as practicing CS and as a Bachelor of Law and Commerce. She specializes in legal and corporate secretarial matters, startup compliance, merger. Namrata has worked as a consultant and advisor with various leading CA firms, startup, government companies, educational institutions, franchisees. She is certified pros trainer and eligible independent director. She is a partner from our branch, Raipur chapter, Raipur branch. She is currently lead Head Start Chhattisgarh advisor to Women Child Department, Chhattisgarh, and its secretary, Raipur chapter, part of startup, and has trained more than 2,000 budding entrepreneurs, one of the delegates of UAE India Startup Exchange. And she has been amongst contributed in the books Eves Against. Can I see the slide, please? And today's welcome, Namrata. And today's our renowned, and I will say the top panelist is Mr. Jyotindra Tiku. Welcome, sir, to the our webinar.
Thank you.
We- we are so happy the kind of experience, knowledge, education you have. I read your profile. It's so big and so enriched. So we are really lucky to have you, sir. Friends, today's our panelist, Mr. Jyotindra Tiku, is a distinguished professional, holds a gold medal in MCOM, an MPhil in financial management, and professional qualification as a CS and CA. He is a fellow chartered accountant. He is also an Indian Corporate Law Service officer from 1987 batch, bringing extensive experience in corporate law and financial management. Friends, this ICLS exams are too tough. I give still lectures and I see the students, very few students can pass this. And so has passed that. With over 22 years of professional experience, Mr. Jyotinder has held pivotal roles, including Registrar of Companies for multiple states, such as Madhya Pradesh and Jammu and Kashmir. He has also served as a joint director in Ministry of Corporate Affairs, contributing oriented critical initiative of conversion of IFRS into Indian accounting standard and implementing the Companies Act 2013. His key achievements and responsibilities include over 10 years of managing the independent administration of the Companies Act 1956, leading e-governance and policy development initiatives for corporate affairs, nearly 12 years conducting inspections, investigations, and scrutiny of financial statements under the Companies Act 1956 as well as 2013. His vast experience and deep understanding of company laws, rules, and regulation have established him as a highly respected authority in the corporate and financial sectors. And friends, I should must mention he has not mentioned his profile. He is a author of various books. Sir, you can name it. That will help our participants to know that. Please, the books you have written.
The books are basically relating to primarily IFRS conversion into NDS. Basically, NDS is the same what we called as Indian accounting standards. In fact, we had an already approved system for Indian accounting standards, what we called earlier times. It was approved in 2006 by the government agencies. And in fact, that came up in line for a number of years with the international bodies also. You know, the problem in that case was taken on a immediate basis for the reasons of Indian companies and the foreign companies put together, conversion of between the two companies, and recognition of their financial statements in the other countries too. For example, if in India also there are certain issues wherein an Indian company who has got a foreign branches or foreign head offices or various other aligned companies or subsidiary companies or vis-a-vis reverse to it also, and they will make it a sort of a consolidated financial statements. Now, the problem in that case was in initial years, in the foreign countries, they would not adopt the financial statements, what was required, what was given as per our Indian Companies Act, and what was approved in the Institute Chartered Accountants also regarding the particular standards. And the secretarial part was, though it was lately merged into it, but though that is also not was they recognized for the reasons that they said that their international financial accounting standards should be adopted. Only then it will be approved by any country for that matter which they have already approved. So in that connection, there was a long process going on with the other companies all over the world also in convergence of the discussions and various chronic issues, whether we are going to adopt those issues or we are not going to adopt. So then there were various issues on that issue because I took an active role on that issue at that time also. It was primarily basically in 2010 to 2014. It took about 3 years or 4 years for the convergence. And for example, we have got roughly around more than 50 odd companies, which have 50 odd countries all over the world, which have they adopted their own accounting, international accounting standards. Now, the same question is that if the balance sheet is being prepared in India or outside India, if it contains the Indian accounting standard, I mean IFRS mechanism or what we call in India, NDS, that is being recognized easy. And there is no problem, no question here then thereafter whether it is correct or not. So those issues can be ruled out. And the basic issue again comes out for the growth of those sectors. Those companies, their growth was dependent on whether they are going to recognize it and then getting the financial assistance from the outside agencies out of our country. Then that was being approved by those agencies for the reasons if they are adopted in India's. India's in called now in India is called ISR philosophy. So IFRS was basically a primary issue framed in London first, then in US and all that. But though US has got some more advanced mechanism as on date, but the problem is the whole issue was for the recognition of our financial statements in out of our country, in the simple terms. Our financial statements, which can be understood by the outside our country, and they can adopt it easily, understanding that India is at par with them. So there is no controversy. That was the basic issue. Yeah.
Thank you, sir. Friends, we have today with us, as usual, Mr. Bala, our moderator. I need not introduce. He is associated with us, and everyone knows him now. And unfortunately, Mr. Sudhakar is not there. He has conveyed his apology to all the participants and the panelists because he is busy with some training program and his another session is going on. So sorry for that. With that, I will say that very important topic. Everyone will be interested to know and we have told Mr. Tiku to share his practical knowledge, experience with our participants so everyone get benefit for the same. So our presentation, I think Namrata has kept minimum to the provisions, but the more is the practical aspect on this topic because everyone has not gone through this inspection, investigation, inquiry kind of thing, and everyone wants to get prepared if they have to face it. So they would like to know how it should be handled, how it should be, attended, what care should be taken, how it take place, what is the process. So that helps you to in future. We wish you don't face that in your own company, but if it is, it's make you ready to face the situation. And for that reason, today's topic is there. And friends, please note that when the inspection investigation and the Companies Act, the officer has very vast power. Though people give too much importance to the income tax raid or income tax inspection, they have less powers as compared to this inspection because this can spread to any area. It can lead to income tax, it can lead to FERA, DGFT, PF, any authority, because this officer, if find that it has some connectivity to any other law and all that, they ask the information and intimate the relevant authority. So one has to be very careful when this inspection, inquiry, or investigation is going on under Companies Act and provide all the information, transparency, and they themselves should know what is their record, what was the events, what were the facts, what are the provisions, everything. And that reason, Mr. Tiku will share with us all his knowledge and experience. Welcome, sir. I'll request you to say a few words on the topic. Mr. Bala, few words, and then Namrata, you can start the presentation. Over to you, sir. Thank you. You can say a few words on the topic, audio, and then we'll start the presentation. Mr. Tiku, sir.
The topic is basically quite interesting as you have narrated in detail to everybody. The subject in itself is quite interesting and more of knowledge and procedural aspects. Two aspects I already narrated to you also yesterday in an informal meeting that in case of this system of as per the Companies Act, there are certain procedures to be done as per the rules and as per the law. But there is a procedural matters also which are not open for the public also for the reason how the procedure is to be adopted, how it has to be done, how activities have to be carried out. Now, in case of, as I already said, inquiry under 207 is there, then 206 is there also, 207, 209, 2010, 2012. These are all connected with the inquiry, inspection, and investigation. Though under the Companies Act 2056, it was only comprising of 2002 to 209A relating to the Companies Act. And then for investigation, it was connected with the 235 or earlier Act. Now things are changed. In the new Act, 2010 is the central government's role where to make an appointment of inspector for on the registrar's report. Means registrar of company has given certain report on that case which is of public interest, having certain special resolution by the company to carry out the investigation under section 210 of the Companies Act. Now the fraud cell, as you have also narrated, that the powers of the income tax have been also are much more wider than these. But here you can say, in case of SFIO, that act has also included those some of grave powers also for raids, also for seizure also. There are a lot many powers have been given by the government under the SFIO Act also. So they have got disciplinary agency established under section 211 and investigations complex in case of fraud cases is connected, and the powers relating to arresting an individual or conducting in-depth inquiry also falls within this range under section 211. Then SFIO can carry out the orders on the basis of the public interest on the regulator or certain regulatory reports. In case of restrictions to apply to other agencies for duplicating agencies under Section 212 of the Companies Act 2013. The powers vested with SFIO. Though giving all the details about that, but that does not mean primarily it is up to the Ministry of Corporate Affairs. SFIO has to also process it to the government agencies, and government will already approve for that. The process of to be carried out by the SFIO also. And the powers of inspection is under Section 217 also, where the inspector may summon, even examine, or require documents for individuals and entities, corporate bodies, or the companies. Employees are going to be a mandatory figure to it for the purpose of taking up these issues, who are responsible for running the show. So this is basically primarily connected with the inquiry, inspection, and investigation, and the primary issues I'm discussing. And I hope this is sufficient, or should I continue with this?
No, sir. This is sufficient. Because you can share it, so we can.
I will share it certain number of issues later.
During the presentation, you can interrupt and give it. Yeah, Mr. Bala, in short, your comment, because we have to start. Everyone has joined.
Yeah. Good morning to all of you. Today we are very much eager to listen what you call from the horse's mouth.
Yeah.
The person
start
who
sharing the screen. Yeah.
The person who had an extraordinary experiences, hand-on experience, handling the inspection, investigation, inquiry, and all other matters. Because maybe many of you would have been faced what you call issuing the so-called notices, answering adjudication process. But the question is there are nitty-gritties when actually inspection happens, when the inspection gets into the stage of the investigations, how the things are all going, that all those things we will listen from him very clearly, number one. Number two, not only that, even when the investigation takes place under the Companies Act, it may also trigger in respect of the other acts as well. Therefore, they have the suspicion there are something is gone wrong, whether related to the incomes or related to other any social security things like, provident fund, gratuity, and other things, and all these things. They have the power to refer these matters to the other department and share their investigation report with them and telling them you may initiate the action accordingly. There are multiple actions also can crop up. That is one thing. Second thing is, again, when the companies are having a multi-layers of companies, where one of the companies is being investigated, and arising out of that, the connected companies, especially what we talk related party transaction, connected companies, associated companies, etc., and all the things, then there could be further investigation in respect to other companies as well also. So really speaking, we company secretaries have to be very, very careful in ensuring the compliance, doing the right thing at all the times. That is very, very important. I think today we will have many, many questions and many, many practical experiences from our learned panelists. I'm also eagerly looking forward the same. With this, I stop here. I'll ask Mehta to go ahead with the presentation. Mehta, please.
So, hi everyone. As all the panelists have mentioned before, that the topic is crucial, though less talked about. So I'll quickly start and get into the topic without much delay. Today's topic is inspection, inquiry, and investigation. Just a quick introduction on the topic. Why is it required? Shareholders of any company are usually vested with various rights and powers, including the right to elect directors and put major decisions across in the company, vote for them. But however, the shareholders are often ill-equipped to exercise effective control over the affairs of the company, and also widely scattered. So at times they do not get the insights of the company, which often lead to complexity, where they are refrained from the exact information, internal informations, etc. And such affairs of the company are usually managed to all intents and purposes by its board of directors, exclusion of a predominant majority of shareholders. Due to such situation, there are cases where abuse of power takes place, by the people in control of the company, mostly the board of directors. Therefore, it becomes imperative for the central government, other bodies who accumulatively have decided, and this section is in place right now, to investigate the affairs of the company in appropriate cases. What are the cases, how it is inspected, investigated, inquired, we'll see later. And with that, this sections, chapter 14, have predominantly came into the picture. This was also there in 1956 Act, but there are subsequent difference between the two acts and sections and powers that have now been in place. So we'll quickly start. Now, why do we need it? Basically, since I mentioned ownership and management are two different things in any company. Most of the cases come from the public listed company where the shareholders are in numbers and scattered. So that's one which leads to the misuse of powers by the board. Second there could be accounting window dressing and malpractices. Third could be to safeguard the interest of not just shareholders but all the stakeholders involved in the company. Now, getting into the sections first, section 206, which talks about the power of registrar, because inquiry, investigation, and inspection, all the three, majorly starts. The center remains the registrar of the companies, who is being first flagged by the some information, some lack of information or situations which needs to call the inquiry and inspection at the first place. So first is company is obligated to provide information, explanation, and documents as the registrar may call off. And registrar will call this documentation either on the basis of scrutiny of any documents which are filed by the company itself in terms of the annual returns or any extra document that we file to the registrar of the companies, or if the registrar receives any information from other sources, the registrar has the power to issue written notice to the company. Now, the registrar in the notice may call for furnishing in writing such information or explanation, or produce such documents and explanation as is mentioned to the company. The time, the mode should be clearly specified in the notice, and registrar has the power to claim and ask for all the details that it deems fit to him. Now, after the issue of notice, it is on the duty of the company to furnish such document and information and to procure those documents and provide the same to the registrar of the companies. It's not just limited to companies, but past employees are also bound to provide and answerable to the registrar for those documents and details that the registrar asks for. Once the notice is issued, it is also mandatory on the part of registrar to make sure that registrar has a written record as to why the notice is being issued. Coming back to the first point, like what triggered the matter, why was this notice issued in the first place? So that reason shall be recorded and returned by the registrar for further records. Now,
Any comment, sir, you want to add, or else you can move? You can add anywhere you want. Please interrupt her. And
Yeah, anytime you are welcome to add whatever you would like to share and add anytime, please.
Yeah.
I would like to have a small sentence added to the same issue. 206 is absolutely correct on the basis of the registrar has the power, but again, it is subject to the condition on the basis of what they have got the information available to them. It is not arbitrarily that he is going to examine all the records, and records are in thousands and hundreds of thousands of companies are existing and they have filed all the, but there must be some sort of information either in writing or in by way of information from any source, by virtue of there is some suspicious about a particular transaction, particular activity, particular sort of an business dealings happening in the, it may be even paper cuttings. There may be a paper news, something like that particular company is going for a negotiations or going for something agreement, though it doesn't have so much of in-depth and how it is going on. Maybe the company has grown very well and all that. Because tomorrow what happens, sir, in such cases, the issue comes up in the democratic, this parliamentary systems also. For example, on a similar type of question that it will be raised by somebody in the parliament. What is the question that paper has got shown like this? A particular company is doing this thing. What is the news about that? So that before all the information that the registrar or the concerned officer of the regional director of a particular area will definitely take up into the action and tell them if there's something like you just see what is the issue. At least some sort of information they will provide. They will get it at their own level also. And if it's so serious about it, it will go ahead. If it is just going as news only, that at least some information will be available to them. Because tomorrow anybody can ask the registrar, this has happened to your area, what has happened to kindly give us some information. At least he has some background about the information to the ministry, to the anybody for that matter. So therefore, this is very important issue. It comes to the knowledge of the registrar in whatever capacity. That's what I wanted to refer to.
Thank you. Thank you. Yeah. So cause is important, right? Some starting. Yeah, Namrata, start.
Yes. Further, section 206 subsection 4 talks about inquiry on information, as I was speaking about, inquiry on information of fraudulent or unlawful state of affairs. So on the basis of information that is furnished to the registrar, if the registrar is satisfied that it is in a mode that needs to be called for the inspection or investigation or inquiry, the business it should look for the following grounds. First, the business is being carried for the fraudulent or unlawful purposes. As Sir rightly said, there should be some trigger point. Without any base or without any scope of fraudulent activities or any suspicion, there cannot be any investigation, inquiry, or inspection. So first there should be any fraudulent activity being going on. The compliance of the company either shouldn't be in place or it has been, treated in a wrong way or wrong filings have been done, or the investor grievances that they raised in the company against the company or to the company have not been answered properly. So in these cases, the registrar may order the company to furnish in the required information within the whatever stipulated time that they mention. Thereupon, the registrar may conduct such inquiry after giving company a proper opportunity of being heard. Now, apart from this, central government also comes into the picture in some cases where central government may direct the registrar or an inspector being appointed for conducting the inspection or investigation to conduct that inquiry. In case the business of a company is being carried on for a fraudulent or lawful purpose of the the officer of the company shall be punishable as provided under section 447, the section of fraud. This we will also discuss in the later slides. Yes. Yes, sir. Further, section 207 talks about conduct of inspection and inquiry. What should be the conduct? What are the process? And here we are speaking strictly about the practical aspect, because it's only when such situation arise when we dig down to the provisions of inspection investigations. So whenever inspection, inquiry, or investigation occurs, every director of the company or every officer of the company need to render assistance to the registrar. There is no escape to it. Whatever information is being asked for need to be provided. And the information to be provided should be in the form of books of accounts that the company has maintained so far. It can be in the form of written documents which has been in place in the company or has been submitted to any other authority, not just registrar of the companies. As Diptiman said in the earlier introduction space, that it's the Companies Act inspection, and this will not be limited only to the Companies Act or to the data limited to the documents that are being submitted to the registrar of the companies. So this scope expands to all the data, regardless of the department. It could be for the labor laws, it could be anywhere, where the suspicion occurs. So books of accounts, all the information as required, and then render also the assistance, like you have to be cooperative and provide all the, not just written recorded, but all the verbal communication as well as the registrar or inspector may ask you for. Further, right of registrar also, expands to the following course of inspection and inquiry. First, they can make the copies of books of accounts because they are only allowed to keep the records with them for 180 days. That's the limit provided under the law. Of course, after completion of the 180 days, there can be an extra uh, expansion of the time or the second term for any additional 180 days. But before that handover of the information back to the company or the officers, the registrar has the rights and reserves the right to make copy of the records or to take extract of the records with them for further internal communication of the registrar on the inspectors. Second, to place marks of identification on the books. For example, they take statutory register from the company and they want to put a mark or book markers in the page. They can very well do that, and in return, where they go back, they should find the exact same bookmarks there where they have been placed. So these are a few small things that the inspection inquiry officer retain right to do so. Third is registrar or inspector to have the power of civil code. Now, CPC, Civil Procedure Code 1908, has confined, inspectors with a few rights. These rights are also applicable to the registrar or the inspector or the officer inspecting in this case as well. So any director or officer of the company disobeying the directions issued by the registrar or the inspector under Section 207 shall be punishable, and with imprisonment extending to 1 year and a fine of not less than 25,000 rupee, but which may extend to 1 lakh rupee as well. Now, in this, there also is a defined table which talks about, what will be the cap depending upon the scale and other scenarios. So this 25,000 is the extent, maximum limit that has been defined in the law. Further, reporting by registrar on inspection or inquiry. Now, Section 208 talks about once the inspection or inquiry is being conducted, registrar or inspector has done the inquiry. They also have the owners to provide a report on what grounds they have conducted this inquiry and what is the outcome of the inquiry that they have conducted. And this report is in written format, and this shall be provided, a copy of this shall be provided to the central government as well. Basis this, the further procedure of maybe search and seizure or further investigation, tribunal intervention, all these things would happen.
Okay.
Could I add some more points to it?
Yeah.
Yes, sir. Can
In fact, as you have said in Section 206 in the last para regarding that 450, that 447,
Yes.
penal action against 447. This is basically, I told you small background about it. It is connected with the fraud. 447 is entirely connected with the fraud mechanism. By virtue of it is to be established that they have done a fraud by virtue of not applying they have done some misleading things, giving a false informations, given the false declarations, or in the statements already recorded, made as a public document. Also, that public document, including the documents which have been filed with the government agencies. For example, a company filing a particular statement of account, wherein there are certain falsification of statements written in there in it. It is not only the public, it is not only the shareholders, it goes to the government agencies also. Once it is established that this has been finalized, it is not correct. This is definitely having some inducive mechanism for making the interest of the company or the interest of a particular part of their activities or whatever it is connected with. It is once established, it comes under 447. Now, again, I was telling you about that 447 is directly connected with those items which have been given in a falsity mechanism. But that those 447 is connected with the various activities, as I was mentioning about Section 129. Is connected with all that which is connected with final statement, and that is connected with 447. Most of the cases are being clubbed because the 129 is normally clubbed with 447 with the intention that the final statements as per 7 or 129 are being misdirected, misplaced, or falsely presented, something like that. under 447. That's one part of it. Second part is then that establishment of those facts. As I will just again mention on this issue, this is a issue relating under 447 is an offense which is non-compoundable. Non-compoundable means they cannot go for compounding in such matters. So I already mentioned there are a number of sections which are compoundable, non-compoundable only. Now, non-compoundable falls within the range of the central government and the government of India only, Ministry of Corporate Affairs, and they will reach to the conclusion whether it falls under that compoundable offense. So they will go in agree and going for a prosecution under the law. There are a hundreds of cases are right now presenting. I mean, being held in various courts, in the various laws also, where even Supreme Court also, there are a number of cases pending under 447 also. Though it's quite a huge task to establish those facts, but the primary aspects are very easily identifiable because he has given certain false information to the particular agency, his government, and other things are made as a public information. Now, coming to section 227, if you come to the second part, next to it.
Yeah.
That page, regarding that, as you have rightly said, that 227, there is a particular that mark of identification, which I was thinking that I just give you a small example about that. The mark of identification, what is it? Basically, those documents which have been brought from the company or company has produced before the registrar at the time of inquiry or inspection or inquiry, whatever it is called, under those particular sections. And if it under 7 is there involved, such cases, and this mark of identification is primarily being carried out for the purpose of if we are able to establish, if the government is able, or the registrar is able to establish certain facts which are not correct, which have not been correctly done by the company in future course of time, and then it becomes a mark of identification to him, to the government agencies to produce before the court or the particular agencies at the time when the prosecution of a particular section will be filed in the court of law. So these are basically mark of identification so that the company does not disown that these are not their documents. And if that identification mark is done by at the time of delivering the original documents back to the company, so that is basically being carried out with the intention of keeping those documents in hand so that company does not have any attempt, any power or any chance of making the deliberation, making changes particular to a particular document. That's basically one part of it. Another part is when it goes regarding to the powers with the vested with the registrar at that time is the powers of a central civil court. Civil court has number of categories as per 1908 Act. Yeah, whenever the notice is received, he has to come, he has to attend, he has to be with the office, he has to submit all the documents, he cannot leave the office unless the permission is granted to him, something like that. But the basic fundamental question in that case is that he has to comply whatever he's being asked to produce the documents, examine it, give us the information in correct way, explain these things and something like that, and does not leave the office until he is being asked to leave. This is all.
Sir, I have two clarification to seek with you. Rather, I want to get it clarified myself.
Please.
When we talked about the marks,
Pardon?
I have seen when you talk about the putting the marks on the document. In one of the incident, the income tax department, not the Companies Act, but under the income tax department, what has happened was they wanted to go through the various documents. So one of them were actually minutes book.
Okay.
The minutes book was actually produced to them. You know, almost something about 100 pages of the minutes book, they have put their income tax seal on each and every page they have signed, where, you know, our officials have actually objected, seeing the minutes book are being only privacy for the directors and other thing and all. You can have the inspection, you can have the things, you can take the extra, you can ask for the extra, we can actually certify and give it to you. Putting the mark and other things are not okay. He did not do. He did, 100 pages with his seal and his signature. Is it valid, sir?
You see, I'm coming to the first Companies Act into consideration, then I'll tell you about income tax mechanism. You see, the system in Companies Act is
Okay.
very simple in such way that whatever identification is
आता
being
बंद
marked,
करना मशीन
Yeah. Yeah,
identification,
please mute whosoever mark is there. Yeah.
if the identification is being marked, as I already said, the identification is primarily
Yeah.
used for the purpose of if the same document is produced before a legal body or a legal agency or a court of law. At that time,
Yeah.
it can be proved by the agency who have got the copy that this was the correct information what we have got from them. And the identification is primarily basically for the purpose that the company should not change the statements what they have recorded before the register, because he must have understood, I should have done, it should have been like this, sentence should have been like this, a figure should have been like this. He may modify these things. That's the purpose of it. That's how we keep it the mark on that issues. Now, question coming to the income tax mechanism is that normally, should I continue?
Yeah, please.
In case of income tax, the mechanism was normally like this. When the statement is being recorded, both the parties do sign before the authorities in income tax a particular statement. Whatever is written or whatever has been established or whatever has been debated or discussed between the two during the course of examination of particular document or examination of final statements or whatever it is, or minutes or what is. Normally, the system is like that. Both the parties would sign the particular statement that is recorded. So that becomes everything proof for everybody who has what has been recorded is already established in the particular statement. Now, here the question arises if the minutes are of 100 pages and 100 pages, if they have marked it as sort of the way they have marked it, that.
Yeah, the seal and sign. That is what they put each and every page.
The seal and sign, sir, my question in this case is sealing and signing is a different mechanism.
Yeah.
The question is basically if they have the powers to seize the documents and they can keep the documents within themselves to a particular period of time also. That's not an issue. Now, question arises if they are examining a particular document as just a pardon document, then keeping it and sealing it at their own level. But the sealing doesn't mean that that means that documents will have to be produced with the income tax authorities only. That means that company will not get back those documents. But sealing means that they have particular sort of a statement or recorded statement which they wanted. But for that matter, they should have a separate notice for that. We wanted a particular documents or particular statement. If it is not there, there should have particular, while taking the possession of certain documents from the companies by the income tax under the income tax laws, they have the powers of seizure of documents. Here, the seizure of a particular document does not matter, does not have much effect, because for the reason there should be a particular order for that, for taking care of those documents. And what you have said is, could you kindly clarify, sir, was the document being produced before him or it was being seized by them?
No, it was actually produced before him. The statements were being made actually. As you rightly said, statement has been recorded. It was signed by both the people.
Yeah.
But he referred, these are all the minutes, these are the meeting. What they have done is they call the minutes book. And each and every page of the minutes book, they have put the income tax to seal. That round seal is there, what they are carrying. That
Okay.
they put in every page. And he has actually signed each and every page for which the officer has objected, but he did not listen. He said, this is it.
No,
That was the issue.
Yeah, to my knowledge, small knowledge, I can tell you this much, but I don't think they have the power to do like this.
That is what I also.
Mechanism. Sir, there is a mechanism for doing this exercise.
Yeah, that is what we also.
Overriding powers. This what I understand.
Yeah.
Because if he wants the documents, make it a copy of it, either seize it or leave it back to it with seizure or whatever we have done in our Companies Act, signing of the both parties, or alternative, as you rightly said, it is 100 pages. It cannot be noted out. So under those circumstances, they can have a copy of it, get signed by both the parties, and get the copy with them. A seizure means seizure means
officer is actually.
I think we can go ahead, Mr. Bala, now.
I think he has exceeded the power in this particular case. Leave it. And another thing, sir, when you talk about this, when you talk about this, fraud, etc., and other thing and all, in one of the cases, some other the company secretary while writing the minutes What
Okay.
has happened? The appointment of the additional director.
Okay.
Some other in the preamble of the minutes, while minuting it, is that the company is considering him to appoint as an independent director. He has mentioned there. But
Okay.
somehow the actual resolution said he is actually appointed as the additional director.
Okay.
Now, what happened? The inspecting official who had come from the Companies Act, they said, I think you're making a bona fide statement here. Your intention is appointing an independent director, but whereas you did something, and what is the thing? So he lodged the criminal complaint, he filed the case in the court of law.
Okay.
Now, the question is actually, the decision which is coming out from the director is actually reflected by way of the resolution. What
Okay.
is the final resolution? Even that is certified, and along with that, the necessary form has been signed. That
Correct.
should be actually taken as the face value. But some mistake has taken place. Instead of writing the director, he has used the word independent director. So
Right.
now this is actually a bona fide intention. You are misrepresenting all the thing he made out, and the case has been actually lodged in a court, and we will have to fight with the case for a longer time. Is it the fair way of fixing? Instead of explaining it, he did not listen. He proceeded with the things have happened like that.
No. To my knowledge, it doesn't fall under 447. It's nothing like it is an accidental problem or what is in. I mean, he has not been able to do it properly in his statements recorded by him. That company secretary has not done it correctly, but that doesn't mean that it's going to have an 447 site of authority.
No. Ultimately, we got the case discharged of the court, but after the
Yeah.
fight of about a year or something like that, it has taken. That is the thing. Because I'm only trying to find out, when we are talking ease of doing the business, etc., and other thing and all, the right way. Sometimes it doesn't happen. That is what I wanted to bring to your knowledge.
I would mention my simple question in this case is the problems in such cases is how we are going to present the matters before the authorities. I mean, for example, I'm just telling you, sir, very simple thing. If these type of questions are, for example, in your preliminary findings letter also, inspection matters, security matters, or other declarations already given in the on investigations also. You see, the basic question arises under these issues, what I could reach to the conclusion that the presentation and legally presenting the matter before the authorities is the most crucial and most important. How we are going to present this reply, present the situations before the authorities, that creates a focal issue. How we are able to present it and make them to understand this is an error, not a fraud, or whatever you call it. Or if we are able to do some sort of statements, reply back to and fighting back against their ill intentions by whosoever is doing it. But my question in this case is very simple. But if we are able to present these type of smaller issues becoming bigger, as you have rightly said, there are some of the other cases also which are contained to for section 219 also, and which are being clubbed with the 447. So there are various issues also which are very smaller in nature, but clubbed into a fraud also. So that is again I'm telling you, sir, how it is to the presentation of certain issues and giving the representations and giving the proper interpretation of what has been interpreted by the authorities or the particular agencies before the law. That's all. Rest otherwise these type of things do happen by way of non-applicability of mind from either side. So that should not be taken as a serious issue, but examination of document is more important. Examination of particular item, examination of particular default, examination of particular error is of important. I'll tell you an instant case. There are certain, a company, for example, sometime back, there were about 8 or 10 violations created against particular sections. Now, after examination of the same situation, after going into detail, I reached a conclusion all the points are not covered because of time limitations. When that matter was forwarded, all the points they had to drop. Otherwise, there's nothing left out. Depending upon, again, I'm telling you, sir, how it is the applicability of mind, applicability of a particular charge, applicability of particular default has to be examined from all perspectives. Only then we will be able to get out of it, subject to the conditions we are going to examine it at the appropriate time. And examination of these is more lucid. And if there is an error, again, I'm telling you, if there is an error, admission of error is the best removal of this list. If certain errors are there, that error can be converted or converted into fraud and other things can be admitted and declared that the situation was not like this. Intention is not that, but this the subsequent effect of a particular transaction is not going to have any effect on a particular body or a public or agency for that matter. Therefore, the intention is quite fair. There's nothing going to happen, anything else, but though it has happened, certain these errors have happened. So kindly be condoned of. This type of situation can do happen.
We can
There
go
is
ahead.
one question actually. There is one question has come to you from the gentleman. Apart from the returns and financial statements, okay, filed by the company, what are the other sources of the information is actually relied upon by the ROC and initiate suo motu inspection inquiry by a company? Can ROC actually extract information from SEBI, RBI, CBI reports for initiating inspection and inquiry?
I am replying this in a very absolutely correct mechanism. How is the procedure? Procedure is like this. If the agencies, those agencies have given certain reports against certain companies for reasons given in the reports, in the public notice, in the information. For example, what happens as times, for example, ROC has certain doubts about a particular company. What they do is that they inform the SEBI also. For example, SEBI has published something against a particular company. Even the ROC can write to the SEBI and get information available from them. What is the reason for the default or what is the problem? Or it may have come in a public, it may have come in a notice, it may have come in from any source of action. Thereafter, it's the ROC has to refer this matter to his authorities for the reasons for which he is recommending inspection, inquiry or investigation or whatever it is, depending upon situation of volume of complaint, volume of information available to him from various sources, as you have rightly said, whether in CBI, whether in the SEBI, whether in from any other sources, but that documentary evidence should be given by to him also. Only then with the documentary evidence he can produce before the authorities for initiating an action against the particular sections.
Okay.
Okay,
Thank you.
thank you. Go ahead, Amrita.
Yes, sir. Okay. So next is search and seizure. So on the basis of the following, the central government may appoint one or more inspectors to investigate the affairs of the company and to report them further. First is on the receipt of report of the registrar as provided under 208 that we last discussed. And also second on intimation of a special resolution that a company has passed. So the company itself can pass a resolution, in which it sorts that the affair of the company shall be investigated. So that's a suo motu move. And third, if it's in the public interest, then then further it can be moved that way. Where an order is passed by a court or the tribunal in any proceedings before the tribunal or the court, then the affairs of the company ought to be investigated. Central government shall order an investigation into the affairs of that company basis that those either of the three moves that we discussed. Further, it also considers to be in place if the books which are seized are being provided by the company is being well signed and executed and affiliated by the company officers itself. It should also be returned, as we discussed in the last few slides, that it shall be returned within the 180 days by the officers or investigators back to the company. Before return, they can, of course, take extract or make a copy of the documents being provided and returned. Next, we have appointment of investigators by central government. So further, so there is a tweak in word may and shall in this section. The central government may appoint one or more inspectors on the following grounds. First, the receipt of report of the registrar or inspectors under Section 208. If the report received under 208 by the registrar or inspector says that it needs intervention and basis that central government may appoint. Further, on intimation of special resolution and in the public interest, as we earlier discussed. But at the same time, the central government shall order an investigation when an order is being passed by the court or the tribunal. So if it's coming by the court or by the tribunal, the central government is also central government will surely pass an order for an investigation. But if it's coming through the reports or the special resolution or in public interest, then the central government reserves the right. It may or may not further carry on for investigation.
True.
Yeah.
Should I?
Yes, sir.
Yeah, please.
Yeah.
The system in this case is like this, as you rightly said, it is a question of inquiry, it is a question of inspection, wherein it has been derived that the investigation is mandatory for the reasons as decided by the ministry. But under those circumstances, what is happening is not only the report has been filed, it is the report which has been filed under 206, 207 or 8 by the government, to the government, by the registrar or by the inspecting officer, whosoever has been appointed in that cases. That report goes to the central government, and central government, what is happening? There is a Director General of Inspection and Investigations Office. They are conducting the examination of the records. After examination of their reports, that what has been recommended by the inspector at that time, whosoever has done it, he has recommended the investigations. It's only subject to that condition. If he has not recommended that type of situation, it may not come up, or it may come up to the government's authority, depending on situation from the other sources, other information available from other sources. But when the inspection report itself speaks about the investigation has to be carried out for the reasons XXX. What is that? XXX means that there are certain fundamental questions by already constituted by him in his report, by virtue of which he is not able to finalize those issues for the reasons that he doesn't have the powers to undergo the investigation sort of a mechanism or to carry out the inquiry of the other companies it's related to it, or its subsidiary holding related, or whatever it is. Under these circumstances, he may refer the cause because of certain entries or certain financial transactions or internal transactions or party transactions or their relative transactions, for which he is not able to establish certain facts and has certain solid reasons to declare that if those things can be made clear, that things can be sorted out. There are some other matters relating to other fraudulent activities carried by them. Now, it goes to ministry. It is not only, I'm just telling to all of you, the issue is it should not be taken by the public as a journal that is an ordinary mechanism. It is not that. It's a too lucid and too hard a job by the that agency also, government agency, to decide to carry out the investigation in such mechanism, because there is an apex committee for that. They will examine it. Then there will a cross-examination will be carried out, whether it is a fit case or not. I mean, not many questions will be raised, whether it's a fit or not, because it's not a question of making just a fun out of a show. It is a question of each and every transaction has to be examined and has to be deliberated in a lucid style and has been declared that there is some true chances of fraudulent activities or mismanagement or whatever it is. And if such a situation is established, only they can recommend it. So the recommendation comes from the government for investigation. Depending upon, I told you, is a lot many exercise to be carried out by in the inspection report itself, that he should highly qualify it. What are the reasons for his investigation? What are why he does want it inspection? What are the background? What is the fact behind it? How many financial transactions can be involved? So I can tell you, as instant cases, there is a company which was dealing with electronics goods. And electronic good, what they did is, it's a very interesting. Hopefully, you love to listen some of the transactions about how the people are doing. They got a lot of finances from the financial institutions and manufactured a lot many items of electronic goods, and they sent it abroad. send it abroad, and when that abroad was, they got a foreign incentives also. Getting because of foreign sales, as you know about it, if your company is getting a lot of exports, and they'll get foreign incentives also, getting that incentive also. But unfortunately, what was seen that no money was coming from abroad back to India as on their sales matter. I mean, how many multi-crores were sold out in the foreign countries, and no money was received from the foreign country for the reasons. It was not being ascertained what is the fact. Then they decided that, sir, those companies must have been defaulted. They did not repay. They are something like they are gone in liquidation. And under those circumstances, neither the inspecting officer nor any person can identify whether they are in liquidation or not. Being in a foreign countries, how can we derive these informations? Even if in spite of it, you can take up the matter with the financial institutions also. Why? Because the financial institutions are giving you the report to the RBI for taking the foreign sales incentives. And then to tell them, if you have got some foreign incentives you have given them, do you know that where the goods have gone? Yes, they have gone. Because they must be knowing it. Everything is routed through only. Then they got that no, nothing has come. Maybe they are not. Maybe something like that. These type of information are connected matters with the fraudulent activities. So ultimately, what they got it was ascertained after investigation that they got this return to their sales and to the other country. To the other country, that company started some other activities in some other country. They have got their own activities now in India. There's a closed venture over in India. This is how the activities are being carried out. In such cases, they have got mischievous intentions. So under these circumstances, understand you prove it. This is the situation. How innocent can come up. This is all. I mean, there are innumerable number of cases, but I'm just giving an instant cases, like for example, case.
Sir, I think
There are two
yes,
questions have been raised. One
Right.
question is actually, can the minutes book can be seized? I think answer is yes, because that was far from the thing minutes book can be seized, I think. Then the next question is, one director of the company seeks to start investigation as he is not informed about the company's activities, and the company has actually siphoned off the funds of the company. What can we do in this particular case?
That director will have to prove himself that he doesn't know the information. That's the core question. Under these circumstances, it's a simple law. If he is not given the full information about the facts behind the scene, and he, being a director, is not an active also. If it is so, then why did he took up this directorship and then took this liability without delivering his liabilities also? It is not the question of being a director only. So that he has to prove himself that he has no awareness of the full facts behind it. Understand that he has some reasons, he has some grounds. Ground realities are to be established, only then it can survive. Otherwise, he will have the same liabilities as others.
So that means he has to approach to the ROC and he has to lodge a formal complaint and he has to proceed on
It is
this
not
matter.
ROC only, it's a question of how he is going to represent his case in whatever way. Whether the ministry, whether in the ROC, whether in the regional director, or wherever it is, he has to refer the matter on a very, very constructive mechanism, which requires a lot of information, because lot many things have to be carried out at the back of it, so that he can ensure the others also, at least they will go to see what he is writing. Otherwise, you see, he is not able to establish himself about these factors, so his liabilities cannot be condoned of.
And one more gentleman is asking in regarding to the minutes book can be seized. He says nowadays, copies can be taken by the web cameras.
That is true.
That is their choice, actually, what they want, actually.
So that is
That's the practical.
normally the powers are there. If whatever the ideologies are there, they are referring to this can be done like this also. That is depending upon the situation. I can't say any what powers are there. That's all.
Powers are there, they cannot.
He has referred his own reasons for that. He should refer the ministry for changing the act itself. That's all.
Okay, go ahead, Amartha.
Okay, sir. So the next topic we have here is Serious Frauds Investigation Office. This is a new investigation office, in the sense a separate disciplinary office has been established, which was first recommended or initiated or indicated rather the Naresh Chandra Committee report on corporate audit and governance. So, SFIO, Serious Frauds Investigation Office, the need to establish this investigation office was to make sure that we have a separate multidisciplinary team that not only uncovers the fraud, but also is able to direct and supervise the prosecutions under various economic legislations through appropriate agencies, because all the officers, all the investigators are usually being burdened by a lot of existing cases, and at times where this needs to be fast-tracked, and a separate authority needs to be there for a dedicated enforcement of the assignment, and hence the need of the SFIO came up, and then hence it was in the picture and it was framed likewise. So it is framed under Ministry of Corporate Affairs, and it comprises of the experts from various field. It is, I mean, consultants or experts from accounting, forensic auditing, law, IT field, because a lot of technical aspects need to be digged in. Legal matters, capital market experts, taxation experts, etc., are there in the committee, usually in SFIO. The SFIO takes up for investigation following types of cases, which are comprised or characterized by complexity coupled with interdepartmental and multidisciplinary ramifications. Second, also where substantial involvement of public interest is concerned. So, in layman's language, you may say that the bigger the cases or the more complex or interdepartmental it is, the more is the need to have a separate office, and hence SFIO is in the picture for that particular purpose. The Serious Frauds Investigation Office shall be established by the central government, and it is headed by a director. Now, second is what all cases can come up to SFIO, how are they investigated, what are the process to it, right? So, SFIO shall be, the SFIO is set up either by government regulation that has been in place earlier mentioned. It has been in picture from 2nd July 2003, and it is headed by a director. Now, after its framing, a lot of cases have been dealt in. A lot of cases that we can refer to in case law have been there, basis which the procedures and the setup has been developed and made better with time to time. First, the central government can assign the investigation to SFIO on the basis of the opinion of the following. First, on the receipt of report of the registrar or inspector under Section 208. Second, again, if the company passes the special resolution that they want an inspection accordingly, then the company can pass the investigation can be passed on to SFIO. Third, on the request of any department of central government or on the request of any department of state government. Now, on either of the above cases, the director of the SFIO may designate the inspectors in any number as it deemed fit to him for conducting this investigation. Once the investigation is ordered by the central government to SFIO, no other agency can intervene the investigation. And also, this investigation is time bound. So there has been various case laws where companies or other stakeholders, other parties try to intervene, but then the statement or the of the final dictation was completely in the hands of SFIO. No other authority had the rights to intervene. Also, there were cases where SFIO was given a time frame to conduct the investigation, but the report was generated after the investigation, and hence it was sorted that the SFIO's report, which came up after the stipulated time mentioned in the order, will not be entertained. So SFIO investigations are both first time bound and second, of course, free from intervention of any other third party. Now, second is SFIO is vested with the powers to arrest the accused. Third, time limits, as discussed, are directory and not mandatory. Next, we have investigation in other cases. So, Bala sir or Tiku sir, if you want to, throw some light on SFIO or any of its proceedings.
In fact, there are a couple of questions have actually come in SIRO. It is SIFIO. They say, is this investigating by SFIO is a standing organization by the department like CBI, ED, or it is actually constituted from time to time depending upon case-to-case basis? That is one question which they asked here. Second thing is all the fraud investigation will be done by the qualified person, for example, certified fraud examiner, or what is the minimum qualification for conducting this examination? Since you have mentioned the course of the discussion that 100 pages beneath sealed, etc., they exceeded the power, etc., that is why he is putting that question actually. Then the third thing is he is asking in this
I think
SFIO,
let's take one by one. Otherwise, the
Yeah.
question will be forgotten.
Okay. First question is a standing organization case to case. I think it is the established SIFO office itself there. The matter is referred, it is ongoing basis. I think it is not case to case basis. Correct? But anyway, this organization is actually established organization like any other things. It is not from time to basis, or it is not a temporary. It is a permanent organization which is there actually. When the matter is referred, it is being taken. That's what my understanding is there. Then the next question is they are asking whether this is any particular qualification, whether it can be conducted only by the certified fraud examiner, etc. What is the minimum qualification?
So next we have, apart from SFIO, also there are multiple cases or other cases where other parties can intervene and investigate. The first one being the tribunal. We have discussed tribunal intervention in the last few slides. The first is investigation on orders by tribunals. Second is tribunal may pass order on application by specified number of members. So in order to protect the small members' interest as well, the tribunal has issued some specification, the law talks about it, where on any application made by not less than 100 members or members holding not less than 1/10 of the total voting power in the case of a company having share capital, or in case where there's no share capital, not less than 1/5 of the persons of the company's register of members in such case can actually call for such investigation. And in that case, the tribunal will definitely order for investigation, which will be further processed. Second, on application made by any other person otherwise than the above minimum shareholders. So the business of a company is being conducted with the intent to defraud its customers and members, etc. Right? So in such cases where fraudulent activity is being conducted, this stakeholders can also call for the investigation. Apart from that, those persons who are engaged in the formation of the company or management of its affairs have been guilty of fraud or other misconducts towards the company or any other members. The member of the company have not been given all the information with respect to its affairs, which they might reasonably explicit, including information relating to calculation of commission payable by a managing or other director of the or manager of the company. So in these cases as well, the tribunal may order for the investigation. Now, further, there's a provision which says that every officer of the company who is in default or persons concerned in its formation or management shall be punishable under Section 447. So it's being treated as a fraud as mentioned in Section 447, and 447's provision will be applicable. Further, since it's an investigation, the owners or the charges of investigation usually is being taken by the applicants themselves. So now there's a cap mentioned, like if for the security of payment of cost and expense that the investigation will have in the process of the investigation will be incurred, that will be in the beginning itself taken by the applicant, taken from the applicant. And the cap is like if the turnover of the company is up to 50 crore, then the amount of security stays 10,000. If it's from 50 crore to 200 crores, the amount of security is 15. And then if it's more than 200 crores, the amount of security is 25,000, which is the topmost limit. Of course, the security amount that is being taken here will be refunded to the applicant of investigations results in prosecution. Further, we have section 215 talks about the parties which will be excluded and cannot be appointed as an inspector. It's very simple. A firm, any body corporate or any association of persons shall not be appointed as inspector for the matter of inspection or investigation of the company. The next is section 216 that talks about central government, that talks about investigation of ownership of the company. So just like any other matter, if the matter of investigation is about the ownership, is about the shareholding or the promoters, matter related to it, then the central government may appoint one or more inspector to investigate and report on the matter. And its membership and the topics related to the membership, determining the true persons behind. So they will be first who are or who have been financially interested in the course of company's growth, its success or its failure. The next is who are or have been able to control or to influence company materially in the company's operations. The last topic is about the duties of officers of the company under investigation. So here the section talks about all the officers or the inspectors, as we have seen in last few sections, who have been appointed by the central government or the tribunal in the process. What all duties have been defined is mentioned here. At the same time, the section also talks about the power of inspectors. The power talks about what all documents they can, procure, they can ask for. Second, to examine the oath of any person referred under section 217. Also, as we have discussed earlier, that they are also confined with the power of CPC, Civil Code of Civil Proceedings, Procedure 1908. So these are the powers that are again mentioned in 217. Before going further, if sir wants to talk about SFIO, as we had.
Yeah, and also there are questions.
Yes.
There was a connectivity issue, so sir was out of the contact. Yeah.
Sir, you're on mute actually. You'll have to unmute. Thank you, sir. You're on mute.
Mute on.
Yeah. There are certain questions for you. They are asking,
Yeah.
either SIFO office is a standing organization department like CBI or ED, or it is constituted from time to time depending upon each case.
Yeah. Look, there was some problem in the line again. Could you kindly tell me the question again?
Yeah. They are asking, this SFIO is a standing organization or department, or like a CBI or ED, or is it actually constituted from time to time for a specific case?
Yeah, I'll tell you about it's quite a good question and a very important question also for a knowledge sake. This is basically absolutely true that the organization has its own act, has its own passed by the parliament. It's a SFIO Act itself. But it is not like CBI or other agencies, because otherwise also this SFIO office is being controlled by the Minister of Corporate Affairs on. Number two. And number three is whatever is the, office procedure. I'll tell you about the full details about how the matter is being proceeded in the SFIO also. Overall, for their mechanism for operating investigations. This is basically primarily, I told you that this is an act controlled by Ministry of Corporate Affairs, though being in separate act itself, but all administratively controlled by Ministry of Corporate Affairs, and all the issues have to be examined and certified and or rather verified by the Ministry of Corporate Affairs, only permitting them to do whatever the activities they have to carry out. Now, regarding the question of taking the issues, this is an organization which is multiplus activities are being carried out for the reasons that this only not the Ministry of Corporate Affairs officers are there. There are various officers from various agencies also. For example, income tax people also, revenue service also officers are there, police service officers are there, then railway service. I mean, various facial activities. That's why how the various activities are, officers from the various services are being involved in this type of service. Now, what is happening in this case is investigations are being carried out, which contains a different type of ministry, different type of officers from different ministries, different services, clubbed together, though they have their own experiences and expertise on their own way. And it may be 2 officers, 3 officers, depending upon situation to situation, to carry out the investigation of a particular company. Now, the question arises here, how do they do it? This is their procedural matter, internal procedure matter, but I can just suggest you that in such cases, when it is SFIO mechanism is being carried out, what they have made the clarification in this case also that they take the services are certain professionals also from outside also. Outside means who are practicing CAs, practicing company secretary, or practicing, who are empaneled in the list of SFIO also, and they appoint them also for carrying out certain investigation also. This is how they are doing it, for the reasons to make it a best presentation of report to ensure that they are able to finalize their reports in a proper as per law, as systematically as per the proper law. Now, the question will arise that how these agencies are being clubbed together. That is a government philosophy. We have nothing to discuss on that issue. I am just referring that they have appointed the professionals also from the practicing people also from the market to carry out those activities. But the question in that case is that they have to carry out their investigations in their office only. For example, I'll tell you, there is a system in case of a CBI also making certain queries, certain inspections, certain investigations, or their reports are based on the investigations carried out by the Ministry of Corporate Affairs by way of SFIO or inspection by ministry or from any other source also. They get all the information and employ the people who are in their panel, employ them in their own offices, and they have to carry out their activities at their own level. I mean, in their office only. Similarly, SFIO is also carrying out that exercise at their own level. But that is okay. What is happening is all right. But the question arises that in case of certain summons are being issued or certain notices of your present personal hearing is also connected, they are also being invited to be in the SFIO only, and they are making certain questionnaire also and having cross questions of certain transactions, whatever they want a clarification. That's all about it. And that again, it depends on how they are satisfied their own vision of certain transactions which have been treated as a fraudulent activities, or otherwise they have to prove it and report the matter before them also. And again, the situation comes how they present there in the court of law. That's a separate story which I was telling you initially also. That's all about it.
I think there is a next question. Yeah, there is a next question. I think probably you are largely answered in this question itself what is relating to the next question. What is the next question? They are saying, is it all the fraud investigation will be done by the qualified person? For example, a certified fraud examiner, or what are the minimum qualifications are there? That is what the next question. I think you largely answered. They are taking the practicing people, or they are taking chartered accountant, professional, or company secretaries, etc. I think that answers the question. I think
absolutely here. They are basically getting their names empaneled after a year or 2 or something like that. Empanelment is carried out there, and they carry out their activities in their offices, get their books of accounts, and they are examined in their office. That's the best way.
I think probably in my wild thinking, Yeah, much will depend upon the case-to-case basis. If the case is involved some nature or accounting standard, etc., they might appoint a chartered accountants, or if the thing is legal, they will appoint the legal qualified person, or if something related to the things company secretary, like that, they will be selecting, I think.
It could be something like that, yes.
Yeah.
That's true, but that's an internal mechanism. I don't want to deliberate on those issues.
Correct.
This is all is what's.
Yeah. The next thing is, can SFIO investigate the affairs of the company for matters of the fraud, if any, pertaining to the other ministries or departments other than the company law? I think that also you answered actually.
I have
Yes.
already told you, sir.
You said
basically
actually Ministry of
all
yeah.
those, all this depends upon how the complaint, how the mechanism, it's been controlled by the Ministry of Corporate Affairs only. SFI will not do it of its own. Though small issues they can take up, but ultimately here they approve from the Ministry of Corporate Affairs. And they will understand if the issues are relating to some other activities. Basically, you see, this SFIO Act itself is basically fraudulent act is also connected with all financial transactions. It is an economic legislature law, in fact. Though the powers of seizure, arrest, and these things were not in our Companies Act or even SFIO earlier, these were already the income tax authorities, but they have been empowered with them also with the reasons that economic offenses also has going to become a penal, those fraudulent act. That's how these various laws have been implemented, merged into Companies Act also, in order to ensure that this time being an economic offense is going to be a dangerous for the illegal activities also. And if I permit your just 1 minute again, I'll just tell you this. The economic law is such an important for the development of a country as a whole, because economic law is you see, if you see in the basis of it, NP and other things, other factors are also connected with it. Anyway, that's a separate issue. But that I wanted to tell you, sir, the economic offenses becoming illegal offenses or fraudulent activities also, that's how these provisions have been merged with this fraudulent activities. As you know very well, fraud was never declared, nor discussed, nor narrated in any act for that matter. It is only in 2013. I know how hardly it has been represented, how it has been broadly in order to ensure that the frauds can be detected easily by way of the definition given in such acts and such sections.
Can SFIO investigate the matters revealed now in the case of the Adani Group company? I think we should not talk on this, because what is the news is only coming and other thing and all. I think we should not talk on this. Yeah,
that's the political issue.
This is very preliminary. We should not comment on that.
Yes, sir.
What happens if it is not completed in the time allotted?
Yeah, for that matter, time consumption is being recorded or being given by the permission by the government. This is all how it is happening. Because it happens in many cases, because certain investigations, certain examination of certain documents, it takes time. Sometimes a little beyond limitations, not because of his officers also. It is only but the company also. They also delaying the matters with one reason or the other. For example, I tell you, there were some of the reports again during the course of inspection. 206 or 207 was being carried out. And there were certain other reports from the other agencies involving forensic audit and other audits also, for which they were not able to declare those forensic audits reports to them, because that may contain something more informative for the inspection mechanism also. So that leads to a delay in the matter, but that delay in the matter can be done, extended by the government because of the specified reasons.
I think next one is not the question, he is actually giving you the information to you. In my knowledge, fraud investigation could not be done by the chartered accountant or company secretary. That is what I was thinking. But anyway, thanks. I got the clarification now. Yeah, that's it. Narmada, go ahead.
Yes, sir. So next we have section 218, which talks about protection of employees during investigation and appeal to the appellate tribunal. If the company or any other body, corporate or person concerned in the matter is dissatisfied with the tribunal objectives, it may further prefer and go for an appeal to the appellate tribunal within 30 days of the receipt of the notice of objection. The decision of the appellate tribunal shall be final and binding to all the parties in concern. The provision of Section 218 shall be effective without prejudice to the provision of any other law for the time being in force. So this overrides the other provisions. Power of inspector to conduct investigation into the affairs of other related parties is Section 219. So now we'll be quickly going and we'll touch base all the sections, and sir may throw light on the topics that needs more focus. So 219 talks about the power of inspector, which is being appointed on, as we discussed in the last slides, under Section 210, 2 and 13. Or investigation into the affairs of other related companies or the body corporates, which is or has been at the relevant time been the company subsidiary or any way associated with the company, its holding or subsidiary, whatever. The inspector is in the above said situation shall undertake investigation with the prior approval of the central government. So far as the result of the investigations are relevant in the investigation of the affairs of the company for which he is appointed. 220 talks about seizure of documents by the inspector, where in the course of investigation, the inspector has reasonable grounds to believe that books and papers relating to any company, body corporate, MD or manager of such company are liable to be destroyed, manipulated, altered, or maybe tweaked in any other way, then he may enter the place where such books are kept and seize books and papers after allowing the company to take copies and extract of it. This is with the intention to ensure that the proceedings are done with the fair documentations and informations. Section 221 talks about the freezing of assets of the company. It gives right to the tribunal to freeze the transfer, sell, removal, or disposal of funds or assets or any other property of the company for a period not exceeding 3 years, or to such subject transfer, etc., to such conditions and restrictions as the tribunal may deem fit. Any views, sir, here?
I will just mention some of the areas what you have said about Section 219.
Yes.
As I already told you, that the question is that not the investigations are being carried out in the SFI office also, but at times also it can be taken up at a distant places for the reasons known to the government at that time, whether it's a reason of taking the investigation somewhere else. For the reasons, it may be due to distance, it may be due to some other reasons, there may be some other information which can be mutilated by getting the information from that side. That's one part of it. Another part is regarding the seizure and documents, which I already told you under 220, how the documents can be seized for the reasons best known to what we have deliberated and discussed before and also. And freezing of the documents is as already declared by the, already mentioned in the Act itself, can be done for up to 3 years. And such consents can be restricted by the tribunal itself. For that matter, you see, it goes to the NCLT. All the matters fall within the purview of NCLT, and then that they decide about the situation of particular events. So it is connected with certain, all these sections are related to the particular transaction, particular company or particular activity. It's administrative sort of activities carried within these parameters of Section 218, 219, 220, 221. It's all administrative mechanism described in the Act itself. Nothing more other than, you see, going into the legality of the facts that we can deliberate on issues depending on the situations.
There's another question has actually come.
Sir.
Investigation under Section 213, where this investigation can be initiated only after the court authority finds from promoter KMB to be guilty or fraud of the course after the due process of the law. In such a cases, will there be a dual action by the court and ROC on the same subject matter?
No, basically, you see, once the question arises under 2113 is that if the court has declared that there's a manipulation, there's a fraud, or there's a misuse of funds or whatever it is, that is going to be quite a valid proof for a taken an action under 2113 also. And that will be produced before the ministry. They will definitely create the action for that matter. But if the matter is being already carried out by the simultaneously, it is not going to be a change in the source systems if that audit activity is being carried out, and court has also declared, and court can be also intimated why that letter that the matter is being investigated, however, if the further action is required, because for the information or for the disclosure of the matter before the court, that they will come to know that simultaneous activities is being already carried out and to intimation to the court itself.
Okay. Go ahead, Nurmata.
Nayan.
So next is inspector's report. I think the report, the section talks about this is 223. So, there are four sub-pointers that we can discuss here. Looks very important section to me because the first is interim and final report, in which depending on the nature of directions given by the central government under which the investigation has taken place, the inspector may submit interim report if in the due time, as Sir mentioned, that the time frame can be, extended or reframed. But in the due time, whatever the status has been, in accordance with the inspector. So that interim report will have to be provided by the inspector to the central government. And on conclusion of the investigation, he may then give the final report. Second is that the report should always be in writing that can be referred to for future investigations and records. Every report shall be provided in a printed copy to the central government. Third, right to obtain the copy of report remains to any person who is interested in the company or who is anyway stakeholder of the company or is being affected by the proceedings of the investigations. Third, last is that this report, which is either interim or final, this will be admissible proof in the courts for any other parallel proceedings which are going on and can be referred to for that matter. So this was section 223. Now, next we have exception. That this section, nothing in this section shall apply to a, sorry.
Yeah, I will refer to this is a very, very important section. 2 to 3 is very important in itself. I'll just deliberate for 2 minutes only the issue relating to the final interim report. What is happening, as I have perhaps given you small indications about yesterday, though I'll give a small note about that also, just one sentence. In case of inspection, I told you, inspection under 206 or 207, then you will get a comparison between the two just now, after getting to know what is inspection, what is inquiry, and what is investigation. Inquiry may lead to inspection or may be concluding inquiry also. That depends on situation. Now, inspection, after carry out the inspection, I told you there are 4 patterns of making a report which is being filed with the regional director, and then it goes to the central government. Now, 4 reports means that A, B, C, D. A means those which offenses which are non-compoundable. Then D report under head B comes under compoundable issues. Then C comes under the categories which are relating to the ROC, I mean compoundable again. And the D is containing with the, if we are making the references of a particular complaint or particular information or particular default from various acts, from various authorities are already exercising their own rights to carry out. So, for example, income tax matter is going on there against them, or we have a doubt about the income tax, we are referring to that income tax matter is there. Other matters relating other agencies already relevant. I can refer the matter to those, but in calling those points in the part 4 of the report. But that part 4, before going to make the finalizing the report has got the categorization of an issue of a preliminary findings letter by the ministry, by the person who has carried out the inspection through the approval of a particular regional director. Now, after issue of that preliminary findings letter, that is basically the basis of the defaults what the company has carried out during the course of the time of inspection for which the inspection has been carried out, and particularly for those items which have contributed a particular contravention of particular laws. Now, what happens in such cases? that preliminary findings letter goes to the company, then they replies back to the inspecting officer or that particular wherever it has been started out. Then the reports is being categorized under various categories. What was the reply? What was the question raised by IO, means inspecting officer? What was the reply by the company? And then what was ultimately concluded by the inspecting officers at his level, whether the reply was satisfactory or it was not satisfactory for the reasons, whether it should be continue as a default or it should continue as an exemption to the default, what has been raised. Now, third and fourth comes in the ministries. It goes to ministry, then they will also examine it in all polymer manner and reach the conclusion whether it's a default or not a default, depending on situation of a particular item, what is raised in this case. And the last is when it is approved by the ministry that this is a default to be carried out and the prosecution has to be carried out on certain items. This is correctly a default. So this is how the procedure for inspection mechanism is created. Then a letter comes from the ministry, orders to the regional director, or the regional director issues the letter to the concerned company. These are the defaults, and then prosecution will carry out. This is one part of it, and inspection. Now, if it goes for investigations, the same company may go for investigation also, which will means that inspection areas will continue as it is. What action has been taken up, that may continue. Or alternatively, it may be deferred for the reasons of investigation too also. It depends upon the situation of a particular case. Now, in case of investigations, the report is in a different style. There is no mechanism of asking the questionnaire to the company on what certain grounds. Now, what to do is investigations are being carried minutely, considering the various activities, and then they are being called in person also, making their own personal presentations, personal observations, personal opinions on the particular transaction. If the SFIO has certain reasons to ask to these people in order to make their reports. Now, what they do is they will frame the report as per their observations and examination reports by oath, by records, by whatever means. They are making the reports, and then they make a preliminary, or what we call it is a supplementary sort of, not a report which is submitted to the Director General. Director General is examining their reports, may ask certain questions for a final query, or there are various issues connected in the matter that if the idea of taking investigation of a particular company have been established or not, means if the idea of taking the investigation of a particular X company was to conduct a source of information from one angle, other angle, for example, a shareholding problem was there, cheating problem was there, a forgery item was there, transfer of funds was there, or like there are a number of cases like, as you know very well, even Satyam cases, how it has happened, or even number of other companies also, lot many issues have taken up. And what they do is they will make a report on the basis of what has been asked them to frame out. Now, framing out the report or investigating the report on those issues, whether they have complied with in full. After compliance of it, only it will be asked for them to make a final report. They will submit a final report to Director General. Director General, then it goes to, after their examination at their level, then it goes to Minister of Corporate Affairs, and the examination of their reports and the reports or all those things that will carry out. That's a subsequent issue. Now, again, the company does not know, as I told you in case of inspection, they know it, what are the reports the company that inspection has report contains. They can make certain exercise. Here, the chance of making any exemption is not possible for the reason because the company or their directors, they will not come to know, other than in certain queries they have been asked for explain in detail, or for their personal appearances, personal recordings have been recorded. Those things they may know, but what report has been formulated, under what sections they have been formulated, they will not come to know unless it goes to the Ministry of Corporate Affairs. And as the law itself says that if anybody wants a copy of it, they have to apply to the central government. Now, central government will decide whether it is fit case to give a copy to them or not to give, depends on, again, the situation, how gravity of the situation is. If the gravity is of a national issue or something more, then they may not give, or depends on, again, the situation. So this is all about the circumstances in inspection and investigation. Investigation, I again repeated that investigation, they don't know, companies don't know anything. What are the problems, what defaults, what are the areas they have been covered with, under what parameters they are falling with, contraventions we are falling with. But they may have some ideas, as I repeat, same thing I'll repeat it, but they have been asked to come in person as a witness, as a, connected to particular entries, and they will be asking the questions, even though how far they were involved and directly connected in the particular transactions also, and taking these things by oath also. As that powers under 1908 or civil court powers also with them. So that carries out during course of carrying out the investigation. Now, I again coming to the back to square one. It is not possible for the people to, for the officers also carry out the investigation in a bigger way. That's how and why the investigation in this SFIO has made panel for carrying out these type of activities to various agencies, various chartered accountants, company secretaries, lawyers, or whatever. They are in practice. And then, after reaching to the conclusion, they will invite them to carry out the investigations at their office. This is how it is carried.
I think the next question you
Sir.
largely answered in this question itself, because the next question says, is there any specific format for furnishing the interim report and final report? If the reports will be circulated to the public or fraudster, etc. I think this you answered actually.
Yeah. There's nothing to be reported, and there's no specified mechanism. There's a specified mechanism to the extent what type of inquiry it is, what type of investigation is going on. You see, what type of frauds are there, they will have to just format accordingly. So inspection is a separate. I told you that they are separate, this is separate. So these are two distinct different systems carried out. So that's a voluminous. SFIO's report, investigation report is too voluminous. Also, at times, I know it in various companies, the reports are covered in various rooms also. I mean, so voluminous reports are, because it is recording statement, then it is annexure, then it's a too huge ask.
Yeah, go ahead, Narmata.
Okay, sir. So last, we have section 225, which talks about the expense of the complete proceedings that have taken place and the amount incurred in these proceedings. So at the first place, the central government bears the cost, and then the reimbursement is to be made by the following person, depending on the case and extent as applicable. So first is any person who is convicted on a prosecution, or the person ordered to pay damages or restore any property in the proceedings brought under section 214 to the extent specified by the court convicting such person or ordering him to pay such damages or restore such property as the case may be, then that person will be liable to reimburse the exact amount of expense that has been incurred throughout the proceedings. Second is any company or body corporate in whose name the proceedings are brought to the extent of the amount, value of sums or property recovered as a result of such proceedings. In that case, that body corporate will pay the sum. Third is unless as a result of investigation or prosecution is instituted under section 224 that we last talked about, any company or body corporate or MD or any manager indicated in the report, he will be the person reimbursing, or the applicant for the investigation when inspector was appointed under section 213. So in that case, this respective people will be liable to reimburse.
Correct. Absolutely.
Yes. Next, we have section 226. After this talks about that any sort of voluntary winding up or any restructuring of the company whatsoever takes place between the inspection, investigation, or any proceedings related to that shall not stop the investigation. So that was section 226. Next we have, yes, sir.
That's absolutely true.
Yeah.
Even the courts matter, even the matter is related to the certain fraud issues or some other issues or merger issues.
Yes.
or any other sort of issues in connection with the companies, but that investigation is not going to have any effect to it. Investigation will continue as it is, and the court will also not intervene in the matter. They will carry out whatever they have carried out, or if the information is available for the court, they may ask, but otherwise also that has nothing to do. It will continue as it is.
Right. So, okay. So next we have investigation of foreign companies. Just like what all provisions we discussed so far, that applies mutatis mutandis to the foreign companies as well. So no change there. Of course, when parallel laws come into the picture, which applies to the foreign companies, that would be treated as per the governing acts.
Absolutely.
Next we have.
Absolutely. It depends upon the rules and regulations of that company also. Though
Yes.
it has become a little easier, as I said, that IFRS converting into India's has created a good methodology in this case, in case of which foreign companies are being investigated as per the particular laws of that country, because we cannot govern our laws over there, but at least a common law containing IFRS, which is now India's, that creates quite a good image for understanding or going into the details easily for Indians also, or for those also who are carrying out that particular sort of
Correct.
investigations.
So next is section 229. We'll quickly wrap this up. This talks about if any body, corporate, individual, whosoever has tweaked or provide misinformation or destroyed the evidences in any matter, in any way possible, or has influenced any other party to do so, then he will be liable to the proceedings and will be the act will be treated as fraud as per section 447. Then again, 447 provisions will be applicable.
True.
Now, further we have the criteria on which basis the company will be selected. I think throughout the presentation we have discussed this multiple times, but we'll repeat. First, if the complaint has been made against the company. Second, if there is any qualifications shown by the statutory auditors in their report. Third, if references has been received from other government, as we said, state government, central government, or any other department in parallel, like tax, income tax, RBI, SEBI, etc. Fourth, we have if the company have come up, the company who have come out with the public issue of shares and debentures and have reported some sort of non-compliance in that procedure, that would be considered. The last is like companies incurring continuous losses for a longer period and they are subject to suspicion. They will also be covered. Then sixth would be routine inspection like balance sheet, etc., which shows some sort of errors or some sort of, if they highlight some suspicion, then that will also be covered as per section 206.
True,
And then we
absolutely.
also have list what can be inspected. We have discussed that as well. It's all related to the company data.
Yeah, it's connected with all these things. But I will just again give you a small
Sure.
background. If you have a little time, or should I speak?
Yeah, yes, yes.
Yes, sir.
Yes, yes. Yes, yes.
As I
Please, your comment.
pardon.
Yeah, please go ahead.
Please, I said your comment is precious.
Madam, that's I'm obliged. The complaints, as is the first point, is complaints filed by the companies. You see, it's a subjective matter. Complaint is not going to be an ultimate criteria for taking an inspection against the company on the basis of company. It depends upon, again, what type of complaint is, what is the substantive proof about it, what is the base of it. I mean, all those things. Otherwise, this is just a general law made against the company that it can happen if the complaints are like. But complaint should be subjective. It is not there should be a proper objective behind the complaint also. Of a particular reasons of it is not the only case of a company has not disclosed certain things, it has not highlighted certain issues, or he has not briefed out the report as per the requirements of the law. There may be certain small errors or that cannot lead to inspection. Now, again, the adverse opinions by the qualified auditor is again a question of serious matter, because normally auditors do not qualify unless until they have their own reasons to believe it. That is absolutely true. But this can lead to certain type of inspections, provided again the statute adverse qualifications are having certain definitely some basis for something like fraud or something like behind the scene. They have not disclose all the information we should have. And other things are there, references to the government departments, and this is absolutely true. RBI, various agencies, as I told you in inspection, when it's carried out under 206 also, in report itself, part 4 of the report falls that we may refer to the RBI for non-compliances. For example, there are certain issues regarding merger cases. Merger cases is connected with the foreign companies. Foreign companies are connecting into some merger cases wherein the RBI approvals is required, mandatorily required. If such things are not available, we can refer to the RBI also, SEBI also, income tax also, various agencies also, for the defaults which we understand on their act, that their inability of the application of their acts. So therefore, these agencies are involved directly. Then companies can come out with public issue. As I said already, the public issue is not going to be mandatory unless until it is proved that there is something wrong with it. Yeah, in its report, in its utilization of funds or something like that. That was treated too serious some time back also when the public issue was being raised on a uniform sort of a system, but usage was something else. Then it was a big scam going on maybe about a decade or 2 decades back. So and
The next question has come. Yeah, the next question has come. Final
please.
judgment against the fraud will be issued by ROC or any other body.
ROC will determine that the fraud under 447 is on this basis, like what he examines after his examination. He is not going to be final authority to decide that this is a fraud. It will go to the regional director. Regional director will examine at his level. Then the ministry will decide. If ministry considers that this is a fraud, they will approve it for prosecution. Ultimately, court will decide.
Next question is diversion of the funds. There are several reported cases of the diversion of the funds for creation of the several subsidiaries. This also involves a related party transaction. And in your experience, how these sort of the scams are used to actually provisions and investigation inquiry to curb the malpractices for diversion of the funds, and is compact in position that the MCA ROC will wait for the statutory auditor or RBI or SEBI or first to make an adverse remark, etc. That is what he is asking here.
Sir, basically, I'll tell you what has been happening. This is quite a frequent question and a very important question too. Before a decade back also, when this type of transaction was being carried out, what they would do is, I'll tell you certain examples of, I won't name the companies, but I'll tell you the facts behind it. There are many companies, what they have done, they got huge loans from the companies, from the financial institutions, whether banks or other issues, in multi-crores. And what they do is that they had a listed company, for example, initially, and what they do is, and in routing these money from the public funds and from the financial funds, financial companies, banks and other things, they are routing it through their company to their subsidiaries or connected companies, directly or indirectly. Then they are funding them and growing their companies in a better way rather than what they are getting through them. And then making their company as a sick to such an extent, they are just closing the matter and just saying that nothing is happening in the company. These type of issues are in various companies happening since last also past, during the recent past. Now, what activity have been carried out? Is it certain amendments in the Act also have been carried out with the intention that if there's a disclosure of Section 188 is there, 185 is there, 295 is there, lot many sections have been invited, lot of many restrictions have been relevant. But again, the question arises when IFRS has come out. I'll just tell you a small example about IFRS and the NDS mechanism. Very, very clear mechanism in such cases is there that if certain transactions have been carried out, for that matter, it is the description of the company to decide. It is not the question at the law is, they cannot go beyond the law. Law will provide them to whatever they have to do it to that extent. And beyond that, whatever they can do it is for the company, for the management to decide what is the best suited for them. For example, I'll tell you one table containing costing a 100 rupees cost in the North India, it may cost 5,000 rupees in South. Now, these type of informations are being depicted in such a way in financial statements also in a different mechanism in different places of the same item of the same coin. So that is why IFRS has made them personal liable, that if you are able to do it, you decide at your own level, so that law will also prevail upon you to the extent you are able to do it. But when it is going beyond the law will take your own action. But then if the situation is that you have to give the information in a constructive mechanism and give the report in such a way so that nobody is being hurt and nobody gets much problematic issues out of your observations in the report itself. Now, coming to the final conclusion in this case is this law has been amended number of times. Now, number of circulars are being disclosed. Many circulars have come up with amendments, with certain changes again in certain cases, particular sections are saw there. Here, the company of law regarding the fraud cell, it has under section 447, 448 has clarified these facts in itself, which is not showing a particular transaction mechanism. It shows that if you give a disclosed information, that disclosed, if you give a fraudulent information, if you give incorrect information, if you give false information to anybody, that anybody means, but for that matter, even a government agencies or wherever you are finding it. So, but ultimately, sir, it falls on the person to establish it, how it has been misinterpreted. What the law says that you have done something wrong, but it is for the inspection, investigation, it has to prove there that this false information falls like this. They have to prove it at this. This is all.
Then the next
If
question
you
is
able to
asked.
establish these things, good enough.
Next question is asked. During the investigation of the fraud, a jury will be appointed.
Investigation of
during the investigation of the fraud, a jury will be appointed.
It depends upon the question of, you see, what it is being framed by the government. Government will decide at their own level first. If it is a fraud to such an extent, they will definitely go into the action, and the directors and take the action the other way also. In addition to that, what action they are going to refer to the court to decide the matter.
Sir, I believe the jury system, which was there much earlier, I think that has been actually dispensed with that famous case of Nanavati versus state of.
That is, sir, that is what I was telling you.
The jury system is already gone, I believe.
No, that is no more in existence for the reasons that jury system was sometime long back, but that system is no more. But still, there are certain mechanism being created, if not directly jury, it's an indirect set of mechanism by virtue of which they appoint. What they do is, government will appoint an action against those directors who have done this type of mischievous activities and taken up the actions the other way also. There are various mechanisms carried out. I may not disclose all the facts, but the jury mechanism is not there. It is ultimately for the government to decide whether the ministry will take action, and then the court will decide the matter in case of frauds. Whatever they have already committed, they have established those frauds by way of transaction-wise. A particular transaction of multi-crore transactions have been transferred from this company to that company, X company. It comes from 0 to 1. For example, there was a company which was having a zero capital initially and made a zero capital, and when the conversion of funds were transferred into the loan scheme, loan mechanism. So there's an expression of facts by observation of in the report itself.
Yes, Narmada, go ahead. I have finished with the questions.
Yes. So, so we have talked about the penalties where we discussed what all sections would be covered further. The criteria we have discussed, what all inspected we have discussed. Then there are secretarial action points, which should be, as sir also mentioned earlier, what all should be, ensured before inspection or during inspection. Like the company, any which ways we believe that it must be well complied. The filing should be up to date. So all these pointers are briefed here. I'll just skip in the matter, in the favor of time. Further, we have consequences in which it is mentioned that what all provisions we have discussed earlier, the proceedings, if goes that way, the information which are used will be, considered to complete the action points as mentioned in each of the sections. Prosecution for criminal liability will also be covered under Section 224. Application of winding up, which might have been applied, before investigation or during the course, will be treated on just and equitable ground, but also considering the Section 226 that we discussed, which says that whatever proceedings will be, investigation should prevail and would be, governed that way. Next, we have consequences of undue fraud will be, treated as per the last section is discussed in which the penalties were, linked to Section 447. And then we have information of interest to other government departments. So any records would be taken by any departments which will be needful for, further course of actions. Now, the officers in default, as specified in Section 260 of Companies Act, which cover the list mentioned here, will be affected and will be considered as the parties involved or the officers for the matter of investigation. These are whole-time directors, KMPs. If the KMPs are not there, then all the directors under whose consent or signatures the company runs. Any person or KMP who is charged by the board of directors, any person whose directions board act. So if in the professional capacity, any person has, taken charge or has mentioned that way. I'm sorry, did I stop the screen?
The screen is not moving actually. Screen is showing here the consequences and remedies.
Yes, sir. So, yes. So I was stating that as well. And lastly, issue of transfer. Then if there is an issue of transfer, then RTAs or merchant bankers will be involved. So, and a part of that, any director who has contravened any provisions will be responsible. So here we end the provisions and sections, and then we may further discuss the case laws. But since Tiku sir has mentioned a lot of times in yesterday's discussion today about the Modi case, so I think if sir can quickly take over and if he wish to, share his experience with the Modi case so far.
Whatever you have raised this at the end of it, 2 to 4 and other sections also are connected with it. You see,
Yes.
these are all connected with the inspection reports and other reports, what has been the ultimate resultant effect. Now, there are fraud cases which have been already established. Everybody knows in what comes in newspapers. Earlier fraud cases of Satyam, Xerox, ILFS. There are innumerable number of cases. One by one, if you go into details, this is quite a long procedural mechanism to describe how they have carried out the activities and all that. But the problem is in such cases, at least the Ministry of Corporate Affairs has been able to do something constructive for the help to the government, for the public, or for the overall, for investigating these mechanisms and creating a sort of a sense of understanding. At least the frauds are being created in numerous ways. Though it is not only in India, although it's elsewhere also, abroad also it has been happening. But at least this type of agency, we are trying to do a constructive approach in order to ensure that safety to the nation, safety to the economy, safety to the journalism public as a whole. That's all. Rest, otherwise, there are a number of issues which can be deliberated, but time constraint is there. And we can have it. What I can suggest in future course of time, there are a number of issues. For example, a particular sort of a reporting mechanism from A to Z. It's a 1 hour mechanism how it is decided, and a particular reply will be like this, then the interpretation will be like this, and then the, applicability will like this, and those mechanisms will also quite constructive for the professionals and the public as a large also. In future also, I will just suggest some more things which I propose that my another 2 or 3 books are coming up. I will just give you some more enlightenments in the mechanism, in the development of accounting standards. And as I told you, there's one more book on fraud, a separate book on fraud as an entitled fraud only, which is continuing with 447, 448, and other sections also, which is connected with number of case laws also, and the reasons of how these frauds have created and how it has come and how the act has been enacted. And then why these criminal proceedings sections have been incorporated in the company's law, being an economic legislation. So, and then there's other sections of the 185, 186, 188, 180. I told you, I will also like to give you certain sharing experience and the practical experience by law itself in future course of time.
So I
Yes,
think
Namrata.
yes, sir.
Yeah.
So with this, I close the slides here. And any questions, further questions, we have been, taking questions all this while. So any more questions are most welcome. And over to you, sir.
Yeah, you can stop sharing the screen actually. And what all the questions I think we have answered. Let me check up. Yeah, that's all. Nothing else is there. If anybody wants to ask questions, they can raise their hands so we can answer them. Any participants? I don't think any hand is risen actually as of now. Anybody is having any particular question, please?
Because
this
during
stage?
the discussion only, sir has given very
Yeah.
elaborate explanation.
Elaborate thing here shared. Enormous, practical experience today. I am really, really enriched to the greater extent today. What is the reality actually?
Yeah. I think
Thank-
we can close this session.
Yeah.
Thanks,
And my sincere
participants.
thanks to all of you.
Yeah,
and all
thank
the
you, sir, for
participants
your
also.
part.
Yeah, I can
It was a
convey
really,
sincere thanks.
we really get enriched with all your knowledge and experience. Thanks a lot. We will ask you again for your time. Thanks
Thank
a lot.
you.
Thanks
you.
all the
Thanks, sir.
participants.
Thank you.
Thanks,
Thanks, ma'am.
Thanks a lot to you, sir. It's
Okay, all the
really
best.
great thing to
It's a
listen from
great
you.
pleasure to see you also, to have a deliberation with you. Really, Professor Saab, I really convey my sincere thanks. And to Madam Pooja ji, and Deepti. Madam, thank you very much. Thanks a lot.
Thank you. Thank you.
Thanks a
Thank
lot.
you.
With this, we close the session.
God bless all of you.
Yeah,
All
we'll
of-
meet.
thank
We'll
you.
meet yet another session the next Saturday.
Yeah.
Have a good weekend. Thanks a lot.
Thank you. Thank
Thanks.
you.
Bye, everyone.
Bye.
One, thank you.